Welcome back to Winning Isn't Easy. I'm going to talk about UNUM's claim that the policyholder's back pain was out of proportion to the evidence of radiculopathy and what one federal judge did. Now, this is a common bullshit reason that disability carriers like UNUM will deny or terminate benefits. It's the argument that your pain is out of proportion to exam findings or diagnostic studies, and therefore you couldn't possibly be as disabled as you say, much less disabled by the terms of the policy. Now, sometimes they'll get away with this argument because the disability policy or plan has a get-out-of-jail-free card. And I call that get-out-of-jail-free card term the equivalent of the arbitrary and capricious standard of review. You have to legally prove that they've abused their discretion. And unfortunately, many denials are upheld under the arbitrary and capricious standard of review. But that's not always the case. And that's particularly true if the applicable standard of review is de novo, where the federal judge can substitute their judgment for that of the disability carrier. And I want to give you an example. In the case of Chico versus First UNUM, this is a case out of the Southern District of New York. Chico was a tax accountant for D.E. Shaw & Company. In 2013, she started to have fatigue, weakness, and body pain. Her doctors diagnosed her with fibromyalgia and radiculopathy from a back condition. She tried different types of treatment. She even attempted a return to work. But unfortunately, by 2019, she was unable to work, and she applied for her long-term disability benefits. UNUM, of course, like many disability carriers, denied her claim on the basis that her reported pain was out of proportion to the evidence of radiculopathy on examination and that she was able to work. And they suggested that if she was in as much pain as she said she was, that her treatment would be more extensive and her abilities at home would be more limited. Fortunately, the judge used a de novo standard of review and concluded that both the subjective and objective medical evidence was there to support her claim. All of her treating physicians determined that she was disabled. And of course, UNUM's physicians never examined her and they discounted the records. And I think that was a great win. But I'm sure that if and when her claim is denied again, they're going to have her undergo a liar for hire independent medical evaluation to create a reason to deny her claim. I guarantee you that that's what they're going to do. I don't want you to have a disability carrier like UNUM or anyone else rob you of your financial peace of mind by denying or terminating your benefits for fibromyalgia or even radicular pain or any other medical condition. You can see, in my view, that it takes a team to get a person their disability benefits. And that means that you need to be represented by an experienced ERISA disability attorney. And any of the attorneys involved in the cases that I've cited are great disability attorneys. We understand the games that disability carriers play and what needs to be done to attack this denial. I hope that you have enjoyed this week's episode of Winning Isn't Easy. Please consider liking our podcast, leaving a review, and of course, sharing it with your friends and family. Please subscribe to our podcast. It's a way for you to learn more about your rights to disability benefits. If you have any questions, call us today at 727-894-3188. And certainly tune in next week for our next episode of Winning Isn't Easy.